Well, hello everyone, and welcome to this extra episode. It's going to be an interesting one. It's always interesting when I don't have anyone else here and I get to be unplugged. I don't need the headphones on, hopefully, because I won't be doing any videos or anything like that. I just want to kind of, and I know this is one of those things that only the most dedicated of people are going to like, because it's going to be an episode where we're going to be going over the case law and stuff like that more directly when it comes to the Cook v. Trump stuff, getting caught up on that. Mainly, so Saturday night, we don't have what happened last Saturday, where me and Amy are slogging through the docket, spending an entire hour on a filing. We'll do it here. That way everyone can come back if they want to get the full understanding of what's going on. And if you just want the highlights, if you just want the cliff notes of what's going on, you can listen Saturday. It works out for everybody involved. But tonight, that's what we're going to do. In case you weren't aware, so the 10th, that was yesterday, we had the minute order come out. The 9th, so 2 days ago, on Tuesday, we got the actual order, which granted the temporary, well, not the temporary restrainer. That's what they asked for. They got a preliminary injunction instead. We'll be going over that. Just some house cleaning that also happened yesterday. There were, it looks like, 4 other amicus briefs that totally just whoosh over my head. Yeah, I was aware of the James Fish Sticks, as we like to call him, the mental midget who's a big fanboy for Pulte, and is also on Fox News a lot. His amicus was approved. The other 4 that came after him, the court rejected them. So that's the one there, this minute order up here denying docket entries 18, 21, 22, and 25. Just some housekeeping things there for people. Now, I've read all 4 of the amicus briefs. What parts of it can be readable, because I think like all but one of them were amicus briefs filed by pro se filers. I think only one of the other ones had a lawyer. And then on top of that, they like had very little to do with the case. Like, I'll give James Fish Sticks one thing. He sort of was talking about, the Federal Reserve's, job and why it's important to side with the government here, even though that's completely idiotic. So at least I can see why it got accepted, even though it had very little substance to it and was really just not that very meaningful. As you'll see when we get into the actual ruling by the court. These other ones were just off in left field with a lot of stuff. One of them didn't even side with either of the parties. Like, what's the point of filing the amicus brief if you're just... I'm not, enhancing either side's arguments. I'm just here to open my fat gob onto the docket. Sure. Whatever floats your boat. So, where were we? Yes. Also, Monday we had supplemental authority where the Trump administration filed the stay that the Supreme Court granted in Slaughter. Yeah, Trump v. Slaughter. And they're trying to say, well, see, because the Supreme Court on the shadow docket decided to grant the stay until they get the chance to hear on it, then that means we win. automatically. Like, you lose, we win. Judge, don't need to think any much further on that one. Judge Cobb had a different opinion. Everyone is well aware of, because I posted it, that yes, the court did grant the motion for a temporary restraining order, TRO. However, the court restyled it as a preliminary injunction. We'll get to why they did that here in a sec. So let's dive right into the memorandum opinion. I have read this in full. It's a chunky boy, so we're going to try and skip around a bit if we can, because this thing is 40 some odd pages. So strap in, get a beer of choice or an energy drink or something, because this is going to be a bit of a ride. We're going to skip the background. We already know the background. And we'll go to the legal standard. 1 second. Whoop. All right, sorry about that. So, legal standard for temporary restraining order, same as preliminary injunction, so it doesn't really matter. You have to be likely to succeed on the merits. Have irreparable harm. Now, irreparable harm is pretty clearly defined. It has to be exactly what it says, something that can't be replaced. If it could be replaced by money, or, you know, if it could be easily replaced, it's not irreparable harm. Balance of equities. You have to be suffering for more harm than the other party is, the non-movement. And fourth, the general public interest. Now, as they also point out, that since this is the government, that the third and fourth standards merge here, where the public interest is the same as balance of equities, because it's the government that is the non-movement here. And so that's usually what's discussed when we're talking about public interest. What's good for everyone, and usually in most of those cases we're talking about the government. Court rules that that Cook is likely to succeed on the merits. Trump's stated cause for firing Cook likely does not suffice for the for-cause requirement of the Federal Reserve Act. Not surprising, considering even Trump supporters would probably agree that it's kind of pretextual. Like, it's pretty clear that the reason he's firing her is so that he can get someone in to change the interest rate. I don't think he'll get much argument from that, except for the government's lawyers, because if they admit that, like, it's fucking over, done, they lose. The key question is this dispute is the meaning of the term for cause in the Federal Reserve Act. The history of the represented litigation over the constitutional validity of similar removal restrictions is too extensive. Well, if the court thinks it's too extensive to go over, I sure don't have time to go over it. The meaning of for cause in the Federal Reserve Act. The Federal Reserve Act does not define the term for cause. Generally, when a statutory term is undefined, courts look first to what that term's ordinary contemporary common meaning was when Congress enacted the statute. Applying these tools, the court concludes that the permissible ground for cause removal in the Federal Reserve Act are limited to grounds concerning an official's behavior in office, whether they have been faithfully and effectively executing statutory duties. The for cause standard thus does not contemplate removing an individual purely for conduct that occurred before they assumed the position. We're going to get more into that, especially when we get to the government's appeal, which dropped today, along with their request for a stay enjoining the temporary injunction. It's injunctionception or something like that, because the stay is trying to enjoin the injunction. Now if we can just get something to enjoin the stay. Statutory text and contemporary definitions. The government first urges the court to look to the dictionary definition of the word cause. It claims that cause was understood simply to mean a motive or reason or grounds of action. When identifying the common meaning of the text when Congress enacted the removal provision, the court looked to the definition as understood in the 1935 rather than in 1913 for the for-cause removal provision for the Federal Reserve Act was first enacted in 1913, but then, as the court points out, it was removed. And then, it was removed in the 1933 Banking Act as amended, and then was re-added back in the 1935 Act. So that's the one we should go with, because in the intervening time, it was removed. So when it was added back in is the most pertinent time we should look at for defining what for cause means. At the time of the 1935 amendment, it is true that the legal dictionaries define the word cause as the origin or foundation of a thing or a ground of action, consistent with the government's definition, but they also support the notion that for cause was itself a separate term that carried meaning independent of its component parts. The 1933 edition of Black's Law Dictionary contains a separate entry for cause. With reference to the power of removal from office, this term means some cause other than the will or pleasure of the removing authority, that is, some cause relating to the conduct, ability, fitness, or competence of the officer. And now that leans more towards Cook, because the idea is that you have to have something that is around the conduct, the ability of the person to commit the office for which they've been appointed to. Getting back to the whole situation of it has nothing to do with what they did outside the office before they took the position. It has everything to do of what they did once they became the official actor for the government. Perhaps recognizing that for cause has a meaning more than just any stated reason, at the hearing on this motion, counsel for the government suggested a new definition of for cause as any reason the president can think of, so long as that reason, 1, is something other than mere policy disagreement, 2, bears on the individual's ability or fitness to do their job, and 3, was not known at the time of the official confirmation. Oh boy. There's already problems with that, but I'm sure we'll get to that in due time. The position is in obvious tension with the government's preferred dictionary definition approach to cause in its initial briefing, and the government's supplemental briefing does not resolve this discrepancy. Shocker. Legislative context. The president's ability to remove a member of the Board of Governors must also be understood within the original statutory scheme governing the Federal Reserve, which contemplates a degree of insulation from presidential pressure, particularly with respect to monetary policy decisions. As the Supreme Court has observed, when distinguishing the Federal Reserve from other agencies, the Federal Reserve is uniquely structured, quasi-private entity that falls in the distinct historical traditions of the first and second banks of the United States. The historical context in which Congress enacted the Banking Act of 1935 demonstrates an awareness and the importance of such protections. The Banking Act of 1935 was passed shortly following the Supreme Court's decision in Humphrey's Executor, which, oh my goodness, we're going to be talking so much about that. We spent so much time on it the past 2 weeks. How will we escape it now? We won't. Limiting the removal to inefficiency, neglect of duty, and malfeasance in office did not violate the Constitution. In court, the Humphrey's Executor noted the court in Humphrey's Executor noted that the president's power to remove was a coercive influence which naturally threatens the independence of a commission. Even the government agrees on that point, which it concedes that a policy disagreement with a Federal Reserve governor cannot qualify as a for-cause removal grounds. At the hearing on the Banking Act, members of Congress and the witnesses took note of the Humphreys executor case and its implications for the Federal Reserve's independence. Relationship to prior removal statutes. It is I'm already struggling early, and that's not a good sign. It's a commonplace of statutory interpretation that Congress legislates against the backdrop of existing law, i.e., they already knew what existing law was, and if they made a change, it was for a reason. Accordingly, the court finds highly persuasive Cook's argument that the Federal Reserve Act's use of for cause should also be read in light of prior statutory removal provisions for presidentially appointed Senate-confirmed roles. In 1935, federal statutes imposing restrictions on the president's ability to remove board and agency members had two essential flavors. They either provided that the official could be removed for cause, with no further elaboration as to the meaning of that term, or they provided that the official could be removed for some combination of the INM standards that we talked about there, inefficiency, neglect, and, oh man, I should know the last one, but it's not really coming to me. So yeah. With minor exceptions, the only enumerated removal basis appears to be the INM basis. Statutes did not use for cause and INM in the same removal provision. As for the statutes that enumerated either efficiency, neglect, and malfeasance, there we go. I knew we'd come back to it, malfeasance. In office as a basis for removal, not all used all three grounds. So the overwhelming backdrop of enumerated federal removal restrictions for presidentially appointed tenure protected roles at either the time of the 1913 Federal Reserve Act or the 1935 Banking Act were composed of the INM grounds. Neither the Supreme Court nor lower courts have provided a definitive interpretation of inefficiency, neglect of duty, or malfeasance in office, either jointly or separately, in the context of federal removal protections for independent agency members, which is troublesome. But recent scholarship shows that before entering the federal lexicon, these terms carried with them historical meanings particular to the context of public administration and of officer removal. Neglect of duty had a multi-century term meaning failure to perform one's duties in the way that caused specific harm to the entity which the officer owed the duties. Malfeasance in office had the extensive history in common law, colonial practice, and American state law, and referred to a wrongful act committed in the execution of one's duties that caused injuries to others. And inefficiency is the lack of skill to perform their duties. So, that's your INM standards. For cause in the Federal Reserve Act refers to in-office conduct. Based on statutory conduct above, the court finds that the for cause provision in the Federal Reserve Act extends only to concerns about the board members' ability to effectively and faithfully execute their statutory duties in light of circumstances that have occurred while they are in office. There you go. If it happened before, doesn't matter, unless, as we'll get to, I believe, it impedes on their ability to do their office. Say, for instance, It happened before they became appointed, but let's say it was discovered for, tool of argument that a member of the Federal Board of Governors committed murder, and we found out that they were the murderer. Well, I mean, you can't effectively administer office. That would be the inefficiency standard from federal prison. You just can't do that. That doesn't work. So, yes, you could remove someone for cause if they were later discovered to be the murderer in a crime, like they murdered someone. There's things that could happen beforehand. And of course, when we get to the appeal, the government just pretends like they don't understand what all of that means and doesn't understand why that is a particular change in the situation, because it really makes their argument really, really hard when you apply guardrails to their silliness. The historical background shows when creating various agencies, departments, and boards during the period leading up to the passage of the Banking Act of 1935 and enumerating the grounds for removal from those bodies, Congress narrowly focused on the I&M grounds. Cook argues that this court should find that for cause in the Federal Reserve Act is synonymous with and limiting to the prevailing I&M standard. Contemporary usage at the time, though, yeah, we know about that. Traditional presumption of statutory interpretation, however, is that when Congress employs different words, it usually means different things. Yeah. So Cook is likely not correct that for cause and I&M standards are perfectly synonymous, but that statutory interpretation principle also dooms the government's initial argument that for cause means any articulable justification that the president deems sufficient to warrant removal. Congress knew how to state a lesser requirement and did so in a different section of the Banking Act of 1935, which provided that the comptroller of the currency, a presidentially appointed and Senate confirmed official, would hold office for 5 years unless sooner removed by the president upon reasons to be communicated by him to the Senate. So the court is saying there's different levels. There is, the normal president Article 2 power where it's like, I'm the president and you serve at my leisure, be gone with you. And then, like the court says here, that, like the comptroller of the currency, I can't just fire you because I'm president. I have to find something you did wrong, but it could be literally anything. You forgot to stack the toilet paper before you walked out of the office last night. Goodbye. I don't know if it's, that is a communicated reason. I don't like that you forgot to stack the toilet paper in the bathrooms at the Fed before you left the office. So I'm sure it would have to be something more serious than that. But that's how loose that you can practically, state that read that statute to be. He just has to communicate a reason to the Senate, whatever that reason is. But the whole point of that is, if Congress wanted to say that for cause meant that the president could fire someone for any reason, and they just have to communicate that reason, then why do we have this that I've wonderfully highlighted here in the same piece of legislation from 1935? Why would you have two different definitions that mean the same thing? Again, one of the principal factors of law is people don't write things that mean nothing. If for cause means the same as this passage here, then they wrote something that sounds like it's distinctible and different for no particular fucking reason. People don't do that. So for cause has to mean a higher standard above this. And that's what the court is sort of charting the course to. We can't say definitively that it's the I&M standard that is like for every for cause situation. So it's closest to Lisa Cook being right, but the court's saying she's not perfectly right. at the same time, the court's saying the government sure ain't right either. So it's this ground in between. That for cause means something broader than I&M finds some support in the Supreme Court's analysis of Collins v. Yellen, which reviewed the constitutionality of the removal protection for the director of FH. Irony of ironies. Considering the guy who got us into all of this mess. There, the court did not purport to definitively interpret the meaning of for cause, although it noted that the language appeared to give the president more removal authority than other removal provisions, such as one for inefficiency, neglect of duty, or malfeasance in office. Further, the court was interpreting a for cause removal provision passed in 2008, not one passed in 1935. Since 1935, the enumerated justifications for independent agency and board member removal have been expanded beyond simply I&M to consist of grounds such as immorality, ineligibility, offenses involving moral turpitude, and the conviction of a crime. Oh, well, that's good to know. And the logic in Collins demonstrated why for cause in one statutory context may not be the same in another. In relying on cases involving the employer-employee relationship, Collins observed that disobeying an order is generally regarded as for cause removal. But here the president is not empowered to direct the board of governors in the same manner, or to remove a governor for failing to follow his directions. The ability to do so would be tantamount to being able to fire for policy disagreement, which the government admitted it can't do. It keeps backing up into that problem. And again, if for cause means something more than the traditional I&M grounds, the court is not convinced that it encompasses reasons of a different kind altogether than those grounds. And the fact remains that I&M grounds were the key cause recognized in similar federal statutes at the time, defining for cause in 12 U.S.C. section 242 as extending to in-office conduct that is closely related to the I&M grounds, which still provide for cause with some independent meaning of the separate from I&M. The government's alternative reading that for cause means a reason that is, one, more than mere policy disagreement, bears on the individual's ability or fitness to do the job, and was not known at the time of the official's confirmation, is too broad. First, the government's proposed ability or fitness test, particularly when combined with the government's claim that the president's decision is completely unreviewable, puts little functional limitations on the president's ability to remove Fed governors. Yeah, that's kind of the point of the government's argument. We like the unitary executive. We think that the president should be king and should be able to do whatever he wants. And you are just here, judiciary branch, to fucking rubber stamp everything he fucking does. So shut up and do your job. The government's alternative position, one for which it has provided little textual or historical basis, would allow the president to remove individuals even for arbitrary reasons, provided that the president viewed the reasons as relevant to the individual's ability or fitness to do the job. Huh. Moreover, it would incentivize the president and subordinates to dig up prior conduct, however insubstantial, to justify removal from the board, even where the board member had been up to that point performing their statutory duties impeccably. I detect just a tad bit of sass. I detect some shade being thrown at someone's direction. Duck Bill. Second, the government's consensus that conduct that was known to the appointing authorities, the president and the Senate, at the time of the board member's appointment could not be the basis for a later for-cause firing is at odds with the government's theory that the conduct that a president may take into account when making a for-cause determination lacks any temporal limitation. Yup. A little more about that. In its opening brief, the government observes that Cook's reading of the statute as providing for potential removal based only upon a governor's conduct in office would insulate all manner of gross wrongdoings and preclude the president from removing a governor who was revealed to have committed a massive financial fraud so long as it happened before confirmation. But as Cook already mentioned, the government has since recognized a likely exception for that conduct, even that amounting to gross wrongdoing, if it were known at the time of the confirmation. Why should the question of whether conduct satisfies the statute's for-cause requirement turn on whether the conduct was known prior to confirmation? If the past fraud provides a sufficient, and in the government's view, obvious justification for removal under this statute, it is not clear why the fact that a prior administration was aware of the conduct would sufficiently address a later president's concerns about a governor's continued service or cabin what the government otherwise suggested is the president's unfettered discretion to remove officers for almost any reason. The court suspects that the government acknowledges this limitation because a reading of for cause that would permit the president to second-guess the judgment of his predecessor and Congress by removing duly confirmed governors and replacing them with his own nominees would offend the statutory scheme. Removing governors from office based on conduct that was already known and ratified through the confirmation process would allow for just that. Here, parties seem to dispute whether the information about Cook's property ownership and mortgage financing were known at the time of confirmation. The court does not have sufficient information to resolve this dispute, nor does it quite understand how it would go about determining what may have been known at the time of the confirmation hearing. It's a good point. Hi, I want everyone from the Congress that was seated, 2 years, the Senate that was seated like literally 3 years ago now. I want you to bring them all into my court for them to give statements on what was going through their mind. What did you know about Lisa Cook at the time of nomination? Did you know that she may have possibly committed fraud? It's absurd. In any event, it's not necessary for the court to find this fact at this stage. Yep, we're in the preliminary stage of this case. The court rules solely on the legal questions raised in resolving this motion, not questions that potentially involve factual disputes. Yeah, that factual dispute is going to be really interesting if they do go for summary judgment, because this is going to be a factual dispute. And if you have factual disputes, that really complicates things for summary judgment. The government's argument that a rule that does not take into account pre-confirmation conduct would lead to a parade of horribles also ignores that this is precisely the line that Congress has drawn in dozens of statutes over the past century. For the officers that Congress insulated with an I&M protections, pre-confirmation conduct has never been a basis for removal. And even still, again, this unitary executive nonsense when it comes to this sort of thing is craziness. Because again, here is Donald Trump trying to use unilateral power when you literally have a Congress that is controlled by the Republicans. If you hate her so much, she's an executive branch person. Have Congress impeach her. Did this never... Well, I mean, when you got to the Senate, you're probably going to need some Democrats to come along, and that kind of complicates things a bit. But, it's like when we were talking... It's like oh man, that's political stuff. You know what? We're not going to touch that part for now. No, we're not going to get into the whole Doge mess and how if you wanted budget cuts, just pass them through Congress. Oh my goodness. A conclusion that Congress was not particularly concerned with addressing conduct that occurred before the office holder assumed the position is similarly consistent with the Board of Governors appointment scheme. That scheme involves extensive opportunities for investigation and rigorous vetting by both the president who appoints the nominee and the Senate who confirms them. Further, the court's reading of the statute does not mean that a governor's prior conduct could never be related to in-office conduct to justify removal. For example, an approach that focuses on the individual's in-office conduct for performance would certainly permit for-cause removal where an officer is convicted of a serious crime and incarcerated while in office because they can't carry out their duties from prison. So, say someone is later found out to have done something while being a governor on the Federal Reserve Board. Well, you go through the normal judicial process that you would to find someone beyond a shadow of a doubt guilty of a crime. And if they are convicted, well, there's your inefficiency of duty standard on the I&M scale. They can't effectively, carry out their duties from prison like we discussed earlier. So, if she did, and you can prove that she committed mortgage fraud, charge her. Take her to court. If you find her, if a jury of her peers finds her guilty, good. That's how you handle that. You don't get to conjure up magical presidential powers that don't fucking exist to manufacture the Federal Reserve Board that you want to lower interest rates. That's not how that works. Not how that works. Such a conviction would obviously interfere with the ability of the officer to effectively and faithfully carry out in-office duties. Indeed, standing alone, a governor's subsequent conviction would be a sufficient event occurring in office regardless of when the conduct giving rise to that conviction occurred. There you go, government. If you want to get rid of her, charge her and win the case. Prove beyond a reasonable doubt that she committed mortgage fraud, and you'll be hunky-dory. You're already halfway there. You're doing the investigation part. My guess is that's where it's going to stop, though, and they know it. Finally, the court is satisfied that this understanding of the for-cause protection does not unduly infringe on the president's Article 2 powers. The court's reading of for cause provides broader grounds for removal than the removal protection blessed by the Supreme Court in Humphrey's Executor, which permitted removal only for the classic I&M standard. And in Trump v. Wilcox, which raised concerns about the constitutionality of removal provisions narrower than the ones in question here, the Supreme Court made clear that its analysis did not extend to the Federal Reserve Board's for-cause protections. The president's decision is renewable to determine if he has stated a legally permissible cause. The government argues that whatever the definition of for cause in the Federal Reserve Act, this court lacks the ability to review the president's decision. Yeah, that'd be mighty convenient, wouldn't it? According to the government, the determination of cause is committed to the president's discretion by statute, leaving no role for this court. Yeah, that'd be really mighty convenient for you, wouldn't it? The court disagrees. It is true that when a statute entrusts a discrete specific decision to the president and contains no limitations on the president's exercise of that authority, judicial review for an abuse of discretion claim is not available. But where the authorizing statute places discernible limitations on the president's discretion, like for cause maybe, Review is available given that the responsibility of determining the limits of statutory grants of authority is a judicial function entrusted to the courts, just like finding things unconstitutional. Imagine that. The government acknowledges that there are contexts under which Cook's challenge would be reviewable. At oral arguments, the government conceded that Cook's case would be reviewable had President Trump provided Cook with no cause whatsoever. Such a case, President Trump required to remove Cook for cause would have clearly exceeded his statutory authority in failing to do so. In the government's view, however, because the statute does not clearly define for cause, the president doesn't really have to define what cause is. He could say that, she likes fucking Swiss cheese on her sandwich. And, well, not that one, because it has to be something dealing with her job. She was printing fake government bond certificates. I don't know. And that's enough for cause. Actually, that would probably file under Cook's definition of for cause while we're thinking about it. However, because the statute does not clearly define for cause, the president necessarily must make a discretionary judgment in exercising the removal power, and the sufficiency and adequacy of the reasons given is not renewable. The court finds that this is doubly incorrect in the context of this case. First, the government's argument fails because, as discussed above, the term for cause as used in 12 U.S.C. section 242 has definable limits, which includes that a member of the Board of Governors may only be removed for in-office conduct, demonstrating that they are not effectively and faithfully carrying out their statutory duties. Thus, when confronted with a justification offered by the president that clearly does not fall within the president's statutory authority, the court has the responsibility to review it. It is no different than if the president had attempted to fire Cook without cause, or for a reason the government acknowledges sits outside of the statute. It's what courts do. They get to review things when there's definable limits that some people have disagreements on where those lines should be drawn. It is no different than if the president... we got that. In arguing otherwise, the government primarily relies on Reagan versus United States, 182 U.S. 419, 425, 1901, a case brought by a commissioner of the United States Court for the Indian Territory, challenging his removal. In Reagan, the statute provided that commissioners were to hold office under their existing appointments, subject to removal by the judge if the district where said commission resides for causes prescribed by law. Now, this is going to be key. For causes prescribed by law is not for cause. Difference. Those tricky words that get put into laws. The court found that despite the appointment statute's reference to causes prescribed by law, no cause for removal had ever been affirmatively specified by Congress. As a result, the court stated that removal for cause, when causes are not defined, nor removal for cause provided for, is a matter of discretion and not reviewable. Reagan does not control this case. First, it is unlikely that Reagan's analysis even applies to Federal Reserve Board governors. Reagan identified terms of years protections and causes of removal provisions as two separate types of limitations on the ability of the appointing power to remove at pleasure for such causes as it deemed sufficient. Either the court noted were sufficient to trigger procedural requirements that the removed officer receives a notice and hearing before removal. Here, Cook possesses for a set term of years and thus is not covered by the holding in Reagan. Yep. Second, even if Reagan's analysis applied to an officer with a term of years protection, the statute in Reagan is substantially different from the for cause statute here. The statute in Reagan provided that the president could fire for causes prescribed by law. Yeah. But Congress had not prescribed any specific causes permissible or unpermissible. Here, the court determined that for cause is a circumscribed category, the bounds of which are judicially policeable. Similarly, the court does not find that the Supreme Court of the District of Columbia's opinion in United States ex rel. Garland v. Oliver governs this analysis. There, a statute allowed the president to remove justices of the peace of the District of Columbia for cause. While the court at one point suggested that we suppose it would not be that this court can review the president's action for the purpose of determining the sufficiency of the cause which induces him to remove an officer, the statement was clearly dicta. The court itself acknowledged that the proposition was not argued in this case, which was not about the sufficiency of the cause, but whether the president had the power to remove the officer in the first place, which they found he did. And again, the decision would have been unreviewable, and Garland was the sufficiency of the cause. Here, Cook presents an argument that the cause presented was statutorily off limits. Finally, taken it to its logical conclusion, the government's argument leads to an absurd result. While admitting the president cannot remove an official for policy disagreements, the government claims that under Reagan, a removal on the grounds of a policy disagreement would nonetheless be unreviewable. Got you in a catch-22, yeah! Again, the government just wishes that the president could do whatever he wants, and you, judicial branch, you're just supposed to sit there and rubber stamp it. You don't get to tell us anything in the executive branch. We're in charge. We get to do all the things, and you other two branches of government, you're just kind of mild suggestions. The president's allegations fail to state a qualifying cause under the statute, having determined that the for-cause protections in 12 U.S.C. Section 242 restricts presidential removal of members of the Board of Governors to situations where the record of the governor's in-office behavior demonstrates they cannot effectively and faithfully carry out the statutory duties. The answer is clear. President Trump has not stated a legally permissible cause for Cook's removal. So because of that, the court concludes that she is likely that Governor Cook is likely to prevail on the merits of her for cause claims. Also on the constitutional due process claims, Cook argues that her purported removal violated procedural rights guaranteed by the Fifth Amendment Due Process Clause, which required that Cook receive notice and be provided an opportunity to be heard for any for cause removal. The due process rights were likely violated. Cook argues that she has a constitutionally protected right in her continued position as a member of the Board of Governors. As a result, was entitled to notice of hearing before her termination. The government contests that Cook has a property right interest in her position, and even assuming that she does, argues that Cook received all the process due to her under the Fifth Amendment. Remember the whole, if the president tweets about it, that's notice, guys. Never mind if you go to court and make that argument as a lawyer to a judge. Oh yeah, we gave the defendant proper notice. We made sure to DM him on social media. The judge will look at you and go, "Excuse me? Say fucking what, bitch?" There's no way. Like, even Judge Cobb, when the government said it in court, was incredulous. Like, you're not seriously suggesting that a tweet on social media counts as notice, right? The government, dead straight face, just like, yeah, we do. These are not serious people. They are not fucking serious people. We're not going to spend too much time on the whole property right interest thing, other than the government says that, yes, she does have a protected... Yeah, here's the fun one. So she does have a protected property right interest because she is a government official with a fixed term and fixed powers. She's not just some normal government employee that can be fired at will. Cook did not receive sufficient process for her removal. This is the fun one because I think this is the stupidest argument that the government fucking came up with in this whole thing. As I just explained, it's just dumb. Having determined that Cook was deprived of a protected interest, the court must determine whether she received a process she was due. Due process is flexible and calls for such procedural protections as the particular situation demands. Remember, when we talked about the whole AMC thing, the whole postcard thing, if you didn't get your postcard, they didn't give you your due process. No, actually, you were given several methods of notice. The postcard was just to make extra sure. Delaware postcard notice is, in fact, going the way of the dodo bird. In most cases, you get notice through your broker. You get notice through the press release thing. I know I should know it. It's a Thursday night, but like the notice service that companies do for press releases and things like that. Social media. Yeah, I know. I just said social media is kind of dumb, but it's not the only thing. Like, notice to your broker is the big one, considering they hold your shares beneficially. But like postcard notice is kind of going the way of the dinosaur in Delaware. So like they're saying, like, serving due process, it can be flexible. Government's just asking for a really big stretch, really big ask here. In determining proper process, a court must balance the private interest affected by the government actions, the risk of erroneous deprivation, and the value of additional safeguards, and the government's interest, including the fiscal and financial burdens that additional or substitute procedural requirements would entail. An essential principle of due process is that a deprivation of life, liberty, or property be preceded by notice and opportunity for hearing appropriate to the nature of the case. The opportunity to be heard must be given at a meaningful time and in a meaningful manner. Cook argues that she was at minimum entitled to oral or written notice of the charges and an explanation of the evidence and an opportunity to present her side of the story, as were the discharged individuals in Loudermill. The government retorts that even if applicable to Cook's case, those requirements were satisfied here. I can't keep a straight face at that one. I just can't. It asserts that notice was provided when the president publicized the FHFA referral on August 20th, 2025. Cool story, bro. Recall that it was the date that President Trump shared a Bloomberg news story on his social media platform about Director Pulte's referral letter and stated Cook must resign. We'll get to that too, because I know I'm getting ahead of myself in the script here, but like, you can't say that she had a chance to redress herself when you get the news of this referral and then immediately saying that you must resign. Like, it makes clear that the decision has already been made with or without you. You just get to, eat shit and kick rocks. It's just so amazing the fucking pretzels the government bends itself into trying to make these really incredulous and dumb arguments. As for opportunity to be heard, the government appears to argue that this requirement was satisfied by the fact that President Trump waited 5 days after his August 20th Truth Social post before proceeding with the threatened termination. Again, you threatened it. You made clear that your decision was already in, regardless of what she did. The court finds that the due process requirement laid out by the Supreme Court and Loudermill apply to Cook's case. And based on the record currently before it, the court doubts that Cook received any notice or opportunity to be heard, let alone notice and a hearing that were constitutionally meaningful. It is difficult to construe the President Trump's social media post on August 20th, 2025, which itself linked to a third-party news article regarding Director Pulte's allegations as a written notice of the charges against her. While President Trump's comments to reporters on August 22nd arguably indicated that President Trump was considering firing Cook, they fall short of providing Cook with an explanation of the evidence that President Trump was considering in weighing his dismissal decision. Even if President Trump's statements could be considered as having incorporated Director Pulte's August 20th, 2025 social media post, this was also insufficient notice. Pulte's post included a screenshot of 2 pages of an apparently longer letter sent to the Department of Justice, which itself contained corresponding exhibits that we didn't get to see. He just, showed the screen clip signatures. The government does not claim that President Trump, Director Pulte, their staff sent the referral letter or its supporting materials to Cook, despite the fact that the president cited and incorporated the DOJ's referral letter in his letter informing Cook of her termination. Yeah, these are the reasons that we're firing you. Can I see the reasons? No, you just get to see the suggestions of the reasons, and that's good enough, right? Constitutionally. The government argues that Cook has received actual notice of the allegations against her and President Trump's intentions to remove her. Now, the court disagrees. The point of notice in the termination cases is to provide the employee notice of the charges against them and an explanations of the employer's evidence. The court is highly doubtful that Cook should have been required to piece together the evidentiary basis for a for-cause removal from the scattered assortment of social media posts and news articles. Even if the notice provided had been sufficient, Cook's due process rights were nonetheless likely violated because she was not given a meaningful opportunity to be heard. At no point did President Trump indicate that Cook would be provided an opportunity to argue that the allegations were untrue or did not merit removal, or invite Cook to submit such evidence. That's how that's supposed to work. You can't call it meaningful opportunity if you give the person in question no opportunity to respond. And that's why the government's argument is just so fucking silly. Having found that Cook likely did not receive any due process in her removal, the court could stop here. And for time, I'm going to stop with this analysis, and the court continues to go on explaining that the government has a doo-doo argument, but I think that pretty much covers it, and I don't want to spend all evening on this one thing. We're already an hour in, and okay, at least we only got 10 pages left. I kind of want to get to the rest of the stuff before this evening disappears. Cook faces irreparable harm. In addition to showing a likelihood of success on the merits, Cook must establish that she faces irreparable injury absent the request of preliminary relief. This is the tricky one I had when looking at this originally, because I was looking at it from a general employment thing. How can it be irreparable harm to be fired for your job when you can just get it back later if we determine that the government, But if you're a government employee with a fixed term and certain protections, or appointed, you have an actual defendable harm. You have an inherent property right on your job, in your job. It's not just a job that, is replaceable. So, you have actual irreparable harm that we can discuss. The court agrees with Cook's argument that preventing her from discharging her duties as Federal Reserve Governor, a unique presidentially appointed and Senate-confirmed role with significant responsibilities, itself constitutes irreparable harm remediable by her reinstatement only by her reinstatement. The government first contends that this theory of harm is barred by the Supreme Court's decision in Sampson v. Murray, of which held that federal employees seeking injunctive relief must make a showing of irreparable injury sufficient in the kind and degree to override the obviously disruptive effect which the grant of temporary relief is likely to have on the administrative process. In Sampson, the court noted that this concern would typically cut against the general availability of preliminary injunctions in government personal cases. Sampson dealt with the firing of a probationary employee, that's a huge difference, who had failed to establish irreparable harm beyond mere economic loss and reputational harm. But Sampson held out that there may well be cases that so far depart from the normal situation an irreparable injury might be found, and that a district court will have the authority to grant injunctive relief in that genuinely extraordinary situation. Cook is correct that the other courts in the district have almost uniformly found irreparable harm sufficient to meet the genuinely extraordinary exemptions in Sampson. When confronted with a claim of an official being wrongfully deprived of their statutory right to function, particularly when the official occupies a presidentially appointed, Senate-confirmed fixed-term role. Barry v. Reagan. And a bunch of other cases. So, yep, you have a property interest, therefore removing you is irreparable harm. Dillinger. For Bessett, no, that's not what I want. There was one other one here that's kind of silly. Where is it? Maybe we get down to it down here. The government counters that these decisions embracing the kinds of harm that Cook alleged here should not have persuasive force because many of them have been stayed on appeal. That is not the whole story. In several of the cases, a stay was entered, either not granted or not sought by the government in the first place, meaning that they have persuasive value. As for the cases that have been stayed, the court is not persuaded that these stay decisions undermine the district court's logic or irreparable harm as applied to the case. To start, the Supreme Court stay order in Trump v. Wilcox does not speak to whether Cook has adequately demonstrated irreparable harm here. In Wilcox, the Supreme Court granted stays of two district court reinstatements of members of the National Labor Relations Board and the Merit Systems Protection Board because, one, the plaintiff had failed to show that they would succeed on the merits of their challenge, which are significantly different from Cook, because the harms of the plaintiff from being unable to perform their statutory duties were outweighed by the risks of harm for an order allowing the removal of the officer to continue. Wilcox did not directly address whether the harm to the removed officer was irreparable, only stated that such a harm did not outweigh the government's greater harm of having the removed officer exercise the executive power. The government notes that Chief Justice Roberts recently issued an administrative order in Slaughter, one of the district court cases supporting Cook's theory of irreparable harm, pending full briefing of the government's request to either stay the district court's judgment or grant certiorari before judgment. But a non-presidential administrative stay order provides no basis to doubt the logic of Slaughter as applied to this case. Justice Barrett saying, in concurring in denial of application to vacate stay, administrative stays do not typically reflect the court's consideration of the merits on the stay, just that they want the stay. You get the stay. But it doesn't mean that you can't later win on the merits or lose on them. Cook's argument is also not foreclosed by the D.C. Circuit's decision staying the district court order in Dillinger v. Bessett. Besant. In that decision, the circuit granted a stay of the district court's reinstatement of the special counsel Hampton Dillinger. The circuit held that even if Dillinger's removal had been ultra vires, that did not mean that such injury was irreparable and weighed in his favor. The panel held that the circumstances in that case got in the favor of the stay, pending appeal, because at worst, Dillinger would remain out of office for a short period of time. Oops. Balance of equities and public interest favor relief. Again, the court is not persuaded that the harms cash out here as they did in Wilcox. First, Cook's retention on the Board of Governors does not offend the President's Article 2 authority in the way that officers' reinstatement was found in Wilcox and Boyle. Wilcox's theory of harm was premised on the ground that the government suffered from having a reinstated. I do not play D&D, but if the username is a hint, I do play World of Darkness. I have played D&D. I'm just not a big fan of the D20 system. I prefer the D10 one because that's the first one I ever played. I'm curious what a Star Wars evil D&D campaign. Maybe I'll definitely think on it when I'm not on stream. It does sound kind of interesting, not gonna lie. Cook is one of 7 board members that, by design, not intended to be susceptible to policy pressure. Our big suffering. Flattery. It'll get you everywhere. You're the only ones on the Twitch side. I'm multi-streaming. I'm multitasking, hot and heavy. I got some YouTube people too on board on this gravy train. Further, the public interest in the Federal Reserve's independence weighs in favor of Cook's reinstatement. That independence is critical in helping the nation's banking system promote stability. Something that's desperately needed right now. Court would enter in a preliminary injunction against the defendants, Powell, and the Board of Governors, because I'm going to just skip over this because it's really quick and easy. Yeah, sure. Got the same username on Discord, so, well, not on Twitch side. Shoot, it's different. Just Sunny Corax, but anyway. Court acknowledges preliminary injunction against defendants Powell and the Board of Governors. Yeah, because the court can't really enjoin the president. So that's the reason why we had you have the Board of Governors and Jerome Powell as the other defendant, because can't really enjoin the president. So bring in the Board of Governors. We can enjoin them from fulfilling President Trump's order and protect the and protect things that way. So yeah, that is that. I know we spent like what? Oh, good, only an hour, a little over an hour. Yeah, we can leave. And then, like I said, we had the amicus briefs kicked, and then, of course, we have learned yesterday that they basically filed for transmission for notice of appeal. Sweet. So we're here. We're here. The government. It took them one day. It took them one day to basically kick up the appeal. To kick up the appeal And then they got everything together. We'll talk once I get done with the live stream about scheduling. So basically, they kicked up the appeal, and immediately filed for an emergency motion. Now, courts courts favor preliminary injunctions. They also disfavor emergency motions. Like, if your rights are not being immediately threatened, if it ain't bleeding and almost dying, then like emergency orders are generally disfavored. But in this case, yeah, probably makes sense. So they filed for an emergency order. Don't worry as I open this up. I know you guys, you don't get to see the pages. I know over there, 171, no, it's like 20 pages. The rest are them incorporating documents from the lower court decision. So, I might need another beer to get through this, though. Because, man, the government on this one brings out some pretty shite arguments and rehashes their previous shite arguments. Where do we begin? So, yeah, we don't need the introduction. We know why we're being appealed here. We are pretty well ahead on the statements here. So let's get straight to the argument. Because, oh my goodness, it has not gotten better for the government. And considering a stay pending appeal, the court... Okay, we already went over the 4 factors. Likely to succeed on the merits. Irreparable harm, balance of equities, and the general public good, which in this case, because the non-moving party is the government, factors 3 and 4 are the same. Power to remove and thus supervise those who wield executive power on his behalf is conclusive and preclusive. Congress cannot act on, and thus courts cannot examine the president's actions within this sphere. Trump v. United States. Further specified is a matter of discretion and not reviewable. Reagan versus United States. We already went over how bad Reagan is. Reagan considered a court officer who, by statute, could be removed for causes. Again, for causes prescribed by law is not for cause. Like the court. The court you just came from, explain that. Those are not the... We're going to keep having these moments. I can already tell. In fact, let me adjust this a little bit. There we go. I like that better. If there were any review, it would be extremely narrow and circumscribed, which even the district court recognized. Indeed, Cook's complaint does not identify a freestanding statutory cause of action, and her suit boils down to claims that the president acted ultra vires. That method of review is essentially a Hail Mary pass and requires Cook to demonstrate that the president plainly acted contrary to a specific prohibition in the statute that is clear and mandatory. Well, considering that we defined what for cause meant, then yeah, he did actually violate that. The president had cause to remove Cook from office based on her apparent contradictory assertions made to benefit herself. Are these things you factually proved, or are these things that you're just asserting and just hoping we just kind of go along with it? As the district court noted, for cause is long understood to relate to a conflict, ability, or fitness or competence of the officer. No, the lower court did not, but do continue. The governors of the Federal Reserve System are entrusted with the critical responsibility of maintaining the money supply of the United States, ensuring the Federal Reserve notes serve as the elastic currency that can meet the country's demand for liquidity and appropriately using the purchase and sale of government. Cook has been accused of financial misconduct. Yeah, really key word there. Big difference between accused and actually been found guilty of. If those contrary representations were made knowing, like, man, that if is doing a whole fuckload of work there. If those contradictory representations were made knowingly, they could constitute federal felonies. If I had $1 million, it'd be really nice. Oh, boo. Boo, we do not like bots. Get that noise out of here. Begone, fiend. In this litigation, Cook has offered no meaningful explanation for her apparent contradictory statements about whether she primarily lived in her Michigan house or her Georgia house. Like, okay, we're getting into factual, like, this is stuff that we don't do at this preliminary stage, and especially for facts that the government has yet to fucking prove. There's still an investigation going on. Excuse me for a second. I need a beer because this is just getting dumb. Jesus, this administration is driving me to drink. Nothing in the text of for cause suggests that inquiry or notice by the previous administration eliminates any possible cause, or that any immoral or criminal conduct can be the basis for removal. I don't think the court said that it couldn't. Cook's apparent, like, again, we're having some really big problems here. Constitutes clear cause for the president to consider and ultimately order her removal. At a minimum, demonstrates the sort of gross neglect in financial transactions that calls into question her competence and trustworthiness as a financial regulator. Man, just keep reaching. Just keep reaching. I'm sure you'll find an argument that actually works. The district court did not question the ultimate merits of that judgment. Yeah, because we're not at that stage yet. It's called a preliminary injunction. How is it that government lawyers end up sounding dumber than someone who doesn't even have a law degree? It's just craziness. But instead erroneously held that the president lacked statutory authority to consider Cook's actions at all because they occurred before they took off. No! That is not what the court said. Did you even read the order? If you find evidence that can take a case to trial for those claims of mortgage fraud that you are hanging so desperately onto, like someone holding onto a tree root over a cliff's edge, charge her. If she's found guilty, the court said, yes, you can remove her, even though it was before she was nominated and confirmed by the Senate. Like, the amount of incredulous, just willful ignorance by the government in this argument is just laughable. But if Congress had wanted to limit causes to only in-office conduct, it easily could have drafted different language as it did in other statutes. Removal for cause contemplates a broader range of considerations, and indeed the Supreme Court has recognized that a for-cause removal provision appears to give the president more removal authority than other removal provisions reviewed by this court, and specifically constrained for cause with inefficiency, neglect of duty, or malfeasance in office. The district court resisted this conclusion, stating that allowing the president to remove governors from office based on conduct that was already known and ratified through the confirmation process would allow for the president to remove governors effectively at will. It is difficult to understand the district court's concern. Most individuals do not commit Again, you haven't proved this. You're just assuming it to be true. The district court mistakenly viewed the government as consenting that conduct that was known to be the appointing authorities at the time of the board member's appointment could not be the basis for later show cause firing. But the government's counsel simply stated that if it was something that was known at the time, it's much harder to say that the cause later it causes later, because the presumption is that it had gone through the political process. But again, that's not the facts here. Counsel also argued that, is it not though? Is it not though? Because the mortgages were already known. All this documentation Pulte claims is all public information. All stuff that would have been reviewable at the confirmation hearing. So, like, what are we doing here, guys? Moreover, the district court's narrow construction of for cause butts up against the president's constitutionally appointed duty to take care of the laws and be faithfully executed under Article 2. A construct of cause that nevertheless forbids the president from removing a principal officer when there is unrebutted evidence of serious misconduct would raise substantial questions under Article 2. No, because the court... Like, did we read the same order? Did we read the same ruling? Because I feel like we read different ones here. Indeed, the district court seemed to recognize these concerns when it suggested that prior misconduct could support removal if it led to a criminal conviction. Yes, that was the big point. That was the big point. Which kind of defeats everything that you said before that, oh, anything is out of bounds. No. It's just so dumb. While that is obviously true, it's unclear what textual basis the court used to reach this conclusion. Well, I have the same questions about your own arguments, so I guess O for O on that. The court's acknowledgement that the president may consider pre-office misconduct if it results in extreme consequences underscores that pre-office misconduct is not generally categorically off limits. Yeah, the court admitted that, and the court confined it to things that would, in effect, hinder their ability to do things in their duly appointed office. Like, they have to be willfully ignorant of what was actually said in the order and construe things that weren't said, because, like, they know they can't win. That's what this whole thing boils down to. They're just going to throw a bunch of gobbledygook on the paper because they're hoping they'll get to the Supreme Court and Daddy and all the appointed Trump nominees will bail them out, assuming they even will, because they're the ones that wrote the Supreme Court's a little different, guys. Please don't fuck with this. The government is also likely to succeed on Cook's procedural challenge, as there's no basis under the due process clause for enjoining the president's removal of a principal officer. I think we already had the principal officer conversation. To establish due process violation, Cook must show that the president deprived her of a liberty or property interest to which she had a legitimate claim of entitlement, and that the procedure, we're back to Roberts again. Cook does not hold a protected property interest in her position, as a public office is not property. It's not a public. Sole principal officer to the public is inconsistent with a property or contract right. Taylor v. Beckham, is that the same ruling where they talked about an elected officer, which is completely different things? Supreme Court held little difficulty in deciding that an officer appointed for a defined time or good behavior did not have any vested interest in the contract right for his office and thus could not maintain a due process claim. The same analysis defeats Cook's claim here. Like Crenshaw, I'm pretty sure they're just throwing up Hail Marys again. The district court erred in holding to the contrary, mistakenly reasoning that Cook presented a special case because she is an independent agency board member. The court held Taylor an opposite because it involved elected offices. Yeah, that was Taylor. Rather, but Taylor's reasoning was not so limited. Are you sure? Rather, the Supreme Court rejected a property right based on numerous decisions to the effect that the public officers were mere agents or trusts, not property as such. Sure, cool story, bro. District Court was further mistaken in holding that Crenshaw is inapplicable, suggesting that the case simply concerned whether Congress was prohibited from passing a law that would modify an officer's tenure. But that misses the key point that Crenshaw reaffirmed a public office does not become private property merely because its incumbent enjoys tenured protection. Okay, first of all, the naval officer isn't a Man, they are trying so hard to just jam these dumb arguments. It's like that literal Wojak meme of the fucking drooling moron trying to shove the circle into the square hole. The district court rested its due process holding on almost entirely on Cleveland Board of Education versus Loudermill. But those cases concerned whether civil service employees with statutory tenure protections had a property right to right in continued employment. That distinction matters. It must have missed that. Where did we miss? Neither decision purports to overrule Supreme Court's earlier precedents holding that offices are not property. Man, I want to know what's in between those two asterisks there, because I feel like there's some context that the government is sequestered out here. That distinction matters. It defines how officers may be appointed under the Constitution. Again, officers of the Navy or actual government officials? Because I feel like, again, we're missing a lot of context here. The government is just trying to hide under the fucking couch cushions. And at bottom, Cook still does not explain what difference a hearing would have made. That's kind of the fucking point. She didn't get... Cook complains that she was denied a chance to make her case, but she does not allege that she sought to offer any evidence to the president because the president had already said he was going to fire her. He had already foreclosed the ability to... You went to law school. You cannot be this fucking stupid. You just have to defend the actions of a fucking idiot. That's the only reason you could possibly be this dumb. How can you seek out something that the person from which you seek it from has already foreclosed it? I will fire you unless you resign. There's like nothing to discuss there. They've already made their decision. How can you have any sort of chance to make a case to be heard? It has already been foreclosed. Like, this is such a fucking dumb argument, and they keep making it. And it doesn't sound any smarter the more they say it. It just sounds dumber. The remaining factors favor a stay. Oh, I'm sure. You've been doing so well on the previous two. The equitable factors weigh decisively in the government's favor. In fairy tale land, maybe. And the public interest and balance of equity factors merge here. Yeah, when the government is a party. Supreme Court orders are binding precedent on how they apply the stay factors. This court has confirmed the injunctions that require the president to work with the removed principal officers, interfere with the constitutional powers to supervise the executive branch, inflict irreparable injury. Well, seeing as the SCOTUS, no, not SCOTUS, fuck. Seeing as the Federal Reserve has already said that they plan on sticking with the court decision, the court decided the injunction. The only one that's causing like interference here with the regularity of the Federal Reserve would be the government. The district court mistakenly concluded that this equitable calculus does not apply here because Wilcox's theory of harm was premised on having a reinstated officer exercise the executive power, and that Wilcox expressly disclaimed that its analysis would include the Federal Reserve. Well, why does it say that they disconnected? Because it says here that we're still good and going. That was weird. That was weird, OBS. What the heck was that all about? Anyway, that was weird. District Court, where were we? District Court was wrong on both counts. Federal Reserve governors obviously exercise executive power when they promulgate rules that bind the regulated public. Wow, our first all-right argument. Even setting these cases aside, Cook has identified no irreparable harm that would tip the balance in her favor. This court has set a high standard for irreparable injury, and a plaintiff must show that a clear and present need for equitable relief, and the injury must be beyond remediation. In the removal context, these requirements will be met only in a generally extraordinary situation. The district court concluded that Cook had demonstrated irreparable harm in the form of deprivation of her high-ranking public servant role. But the court has rejected the statutory right to function theory of irreparable injury. See Dillinger v. Bessent. Dillinger held that even if the discharged special counsel's removal was ultra vires, a deprivation of his statutory right to function in office was not irreparable. At worst, the removed officer would remain out of office for a short period of time, which was clearly outweighed by the potential injury to the government of an injunction restraining the special counsel. Dillinger did not break new ground, a long-standing rule that, absent a generally extraordinary situation, loss of employment does not constitute irreparable harm. See, again, case law seems to be up in the air on that, but I get, at least this is an argument from the government that I can at least go, it makes sense, which is better than most of their arguments in this. Indeed, although the district court relied on a string of a string cite of cases for the proposition that an official deprived of their statutory right to function has demonstrated irreparable harm. Many of those decisions were stayed by this court or the Supreme Court. Whether the district court's view of plaintiff duties or her alleged harm, they do not support the denial of a stay. Finally, the district court concluded that the public interest in the Federal Reserve's independence weighed in favor of Cook's reinstatement. Even with the Federal Reserve's unique structure and history, its governors are subject to removal for cause, and the president's actions to remove Cook based on her misconduct should strengthen, not diminish, the Federal Reserve's integrity. Yeah, again, big ifs in there. As in Wilcox, the balance of equities counsels against the disruptive efforts of the effects of repeated removal and reinstatement of officers during a pending litigation. Well, you're the one trying to overturn, so the only one that's really causing this repetitive removal and reinstatement is the government here. So that argument, I'm pretty sure, just cuts back against you. I would really refrain from using that. Especially since the Federal Reserve withheld removing her until this order came down. So this whole issue of, we're going to be pulling Cook out and putting her back in and pulling her out and putting her back in, it's all just because of the government refusing to take the L. So we had the emergency stay, and then we had a response and opposition. I don't think I'm going to get to the amicus tonight. We may save that for tomorrow, but we'll see. I haven't actually gotten to read this one. I was getting ready to try and read it, but I hadn't. Let's see where their argument starts. Oh. Wow. They really didn't do much there. There's only a handful of... Wow. Well, we may get to the end. Oh, that was just a certificate. No, that was a certificate of compliance. Okay. I think we can do this. If this is only 6 pages, we may have time for that amicus brief after all. Plaintiff appellee, Lisa Cook, respectively opposes the entry of the administrative stay. Subject to the court's permission, Governor Cook proposes to separately file a Oh, no! No! I did this live stream, and we're gonna have a memorandum of authorities that's gonna drop on Friday. No! How dare you betray me? I thought that this was it, and I could cover all of this and just move on to Saturday. How dare you betray me? Oh boy. The extraordinary remedy of an administrative stay is wholly unwarranted in this case. The government has identified no exigency that would justify an immediate administrative stay that would operate to disrupt the status quo. At all times during this litigation, Governor Cook has been performing her duties as duly nominated and confirmed member of the Federal Reserve Board, and the district court's September 9th order has confirmed that her purported removal was unlawful. Critically, Governor Cook's duties have included preparing for next week's Federal Open Market Committee policy meeting, at which she and other members of the Federal Open Market Committee will review the Federal Reserve's monetary policy, issue statements on market outlook, and vote on interest rates. An administrative stay would threaten Governor Cook's participation in next week's meeting, which is exactly what the government wants. Exactly what the government wants. To tip the balance in favor of cutting rates. In their hope, significantly. And a meeting and potentially plunge FOMC vote into turmoil. In addition, it has the real potential of impacting domestic and foreign markets, as we have seen. Because each time when Pulte made his announcement, the DXY and government bonds tanked. And then again, when Trump said he was going to fire her, USD and government treasuries tanked again. Or no, not tanked. They actually went up. The face value tanked. That's what I meant. So interest rates actually went up because people were pricing in the risk of a dipshit doing something fucking stupid. Get me out of the dollar and get me out fast. The government has provided no justification for such a grave disruption in the status quo, given that exchange stay would be against the public interest, given the disruptive effect of, see, the same thing I was saying. Yeah, I'm going to take that argument you made about the destructive of removals and reinstatements during the pendency of a litigation, and I'm going to take that knife that you tried to use me, I'm going to disarm you and stab you in the gut with it. Yeah, I saw that one coming. All relevant considerations weigh against entering an administrative stay. In arguing that Governor Cook is not at risk of irreparable harm, the government points to Chief Justice Roberts' recent issuance of an administrative stay in Trump v. Slaughter. But as the court below correctly noted in discussing that order, a non-procedural administrative stay order provides no basis. Oh man, I don't know what's in my eye, but it's driving me insane. No basis to doubt the logic of Slaughter as applied in this case. The precedential value of such a stay is especially limited when it is entered by a single justice rather than the full court. In its request for administrative stay, the government relies on administrative stays granted in Slaughter, Trump v. Wilcox, and Grundman, I'm pretty sure, v. Trump. As a threshold matter, the Supreme Court made clear in Wilcox that its analysis did not extend to the Federal Reserve Board's for-cause protection. Whoopsies, as we stated before, this is because the Federal Reserve is a uniquely structured quasi-private entity that falls in the distinct traditions of the first and second banks of the United States. Slaughter is also factually distinguishable from the present case because FTC Commissioner Slaughter was fired, removed, prevented from exercising the responsibilities of office, and sought reinstatement. Here, Governor Cook at all times continued to fulfill her duties on the Federal Reserve Board of Governors, so entering administrative stay would change the status quo. And this kind of gets back to, I think, where Amy was saying that, that Jerome Powell was kind of helping the situation. Like, the government basically saying, we won't do anything till the court tells us to do anything. Lisa Cook's still going to work in her office. Things are going to continue as normal. Oh, stays here. Well, I guess we don't need to change anything. Like, it was perfectly designed to skip over this Wilcox nonsense of you're in, you're out, you're in, you're out. You've just been in. We're just continuing things. And the court agreed with us, so we don't need to change anything. I don't think that was not decided for any dumb reasons. That was intentional. Also has the side effect of pissing Pulte off, which I'm all for. The other two stay orders relied on by the government, Wilcox and Grundman, are equally inopposite. I hate that word so much, inopposite. As the court noted below, the Wilcox stay does not speak to whether Cook has adequately demonstrated irreparable harm here. Further, this court yesterday, in preventing the removal of the Register of Copyrights and Director of the U.S. Copyright Office, an official with fewer protections than the Federal Reserve governors, pending appeal, reaffirmed that there are certain instances where an officer faces greater risk of harm from being unable to perform her statutory duties than the government faces from allowing her to continue serving in her role. This is another such case. As the district court articulated in distinguishing the case from Dillinger v. Besant, Governor Cook's retention on the Board of Governors does not pose the same harms to the administration's exercise of executive power as other removal cases. She is one member of a multi-member body that the government concedes cannot be subject to policy pressure from the rest of the executive branch. Thus, her continued presence on the board does not cause a similar degree of harm. Additionally, the Fed's most important responsibility is administration of the money supply, and administration of monetary supply is not an executive function. That is correct. The monetary structure and system of the United States government, that is not an executive power. That's a congressional power. That's the legislative branch. That is not an executive power, as much as presidents past and present would like it to be. That was granted under the Constitution to Congress to set. Which makes an interesting quandary if, yes, it is a quasi independent agency of the government. And yes, its board members are appointed by the president, but is the Federal Reserve really a creature of Congress more than it is the executive branch? Interesting question. And further distinguishing the case from Dillinger, the district court correctly noted that whereas in Dillinger, the circuit stay addressed only one harm to Dillinger, the deprivation of his statutory right to function in office, here Governor Cook presented additional harms that flow from the deprivation that the DC Circuit did not consider, including those to the agency's independence and possibly that President Trump would shortly move to replace her from the board. The court in Dillinger explained that the wrongful removal of the special counsel Dillinger would not constitute irreparable harm because at worst, he'd be just, replaced for a short time, removed for a short time, and then, could take up his job once the case was done. Not so here. The president has indicated he will attempt to confirm Governor Cook's permanent replacement swiftly, stating, "We have some very good people fit for that position. We'll have a majority very shortly," which kind of also suggests this whole thing is pretext anyway. And specifically, the president has identified Stephen Moran, whose nomination to fill a different board seat has already been submitted to the Senate as a viable replacement for Governor Cook. We might switch him to Cook's seat. It's a longer term. Therefore, I will have more power for longer. As the DC Circuit explained, that could mean that at the end of this litigation, there would be no seat available for which Cook could serve even as the de facto occupant. This case thus is entirely different from Dillinger, where at worst the Senate confirmed office would remain out of office for a short period of time. This consideration further counsels against changing the status quo by issuing an administrative stay. That's a pretty good argument. I don't want to read the memorandum of opinion Saturday, so hopefully we'll find cliff note points and not have to spend a whole hour on it. But that pretty much covers that. I also did not get a look at this amicus brief. In its first decision granting preliminary relief, the district court made several discrete errors. Oh boy. Who is this? Amicus brief, separation of powers clinic in support of defendant's appellant's emergency motion. If you're supposedly for the separation of powers clinic, I don't know why you're supporting the defendant. Right. District court's limitations of cause in section 242 to actions while in office is textually unsupported and risks needless escalation. These seem like arguments already made by the parties. Causes can include policy. Oh. No! No, they don't. And no, they can't. Any required process is not onerous. District Court also concluded that Ms. Cook was deprived of her office without due process. Again, that is incorrect. Even assuming that some of the process is required, it is not burdensome. Here, Ms. Cook was undoubtedly on notice of her proposed basis for removal. Wow, these arguments are even dumber than the fucking government. And a lawyer attached their name to this? You can't make this shit up. This is why I love following this shit. A lawyer attached their name to this 8-page screed made of fucking garbage. Amazing. Good on ya, I guess. One last thing to look at before I pretty much wrap this up, because we're at 2 hours, and that seems a pretty nifty place to stop. This one shouldn't take too long. I found this pretty interesting. I bet we'll get into it at least some on Saturday. But here, let me flip things here, because we're most definitely not talking politics anymore. That was the end of the politics section. Sorry if you missed it. Move things around here a little bit. Sorry. Whee! Probably should have left things alone, but oh well. So we're going to be talking the Logan Paul v. Coffeezilla case really quick like. We've been sort of off and on keeping up with this. It's been kind of quiet. There's been a lot of discovery battles, as you do once you made it past some of the preliminary stuff. Coffeezilla was not granted his, and they said rule on the law, so it makes it seem like they were going for summary judgment, but it sure seemed like a motion to dismiss to me. And so they're going through discovery stuff. Last week we talked about how he's trying to compel Logan Paul to cough up discovery. There's some other stuff in here that I should have gotten, and I need more people to help me get download documents on this case. This is getting expensive. I probably need to go back and get some of these just to clear things up here. But this is the important one here. I wonder what this notice is about. Let me take a quick look. Just want to make sure I'm not missing anything important. What is this notice about? Tell me. Gimme, gimme, gimme. It's only 20 cents because it's 2 pages. Gimme, gimme, gimme. Gimme, gimme, gimme. Gimme, gimme, gimme. What's this notice? Defendant's notice of withdrawal of defendant's motion to transfer stay proceedings. Please note the defendants have hereby withdrawn the motion to transfer. Oh, well, that's good to know. So that strategy's out the window. This one is kind of interesting, though. We already have the background here. So what we want to do, or is the background just kind of all of this? Yeah, this is all just kind of one big block thing. So, Stephen Fendyson, Coffeezilla is an online journalist who investigates scam, fraudsters, and fake gurus that prey upon desperate people. Coffeezilla publishes work on YouTube. Logan Paul, we know who he is. If you don't, what rock are you living under? Media scrutiny on Paul involving crypto pump and dumps. In 2021, Paul became involved with the cryptocurrency market using his celebrity and fame. Yeah, we kind of also know that. Paul started his own crypto project and media scrutiny continued. Paul decided to develop his own NFT and cryptocurrency called CryptoZoo. Yeah, we know about that. Basically, to boil this down, Paul's role in CryptoZoo, yeah, all stuff that we've discussed before. Blames his management team. What the argument... arguments and authorities, that's what I wanted. Oh my goodness. Here we go. Texas law allows for designations of responsible third parties under Chapter 33 of the Texas Civil Practices and Remedies Code, and it applies in federal court. Indeed, it is well established that Chapter 33 applies to all torts governed by Texas law. So basically, Coffeezilla is pointing out, I'm not the only one that is reported on Logan Paul. In fact, my original reporting isn't even what Logan Paul is suing over. He's suing over comments I made afterwards. There was also other additional people doing their own reports. So, we need to decide what of those reports possibly damaged Logan Paul's reputation. And since he's blaming the people he hired from damaging his reputation, in fact, doing a cross complaint in the other lawsuit, the class action lawsuit against CryptoZoo and all the people involved in that they also should be pulled into this to see what damage, if any, was caused by them to Logan Paul's reputation. You don't get to just sue me. There were more parties involved in this, which is why he dropped merging it over into the other case. So he's going to go ahead and try and basically make it, hey, there are other parties that have potential responsibility here, basically breaking it down and making it harder by bringing in these other outlets, the BBC, CNN, Times, New York Times, Bloomberg Law, Business Insider, Economic Times, Rolling Stones, Vulture, Dextero, and TechCrunch. We want to bring them into this lawsuit because they potentially did damages that Logan Paul's not considering. He's just blaming me. We also have to bring in, Ibanez and Greenbaum because, their lies hurt Logan Paul's reputation. So, to that extent, they should be held comparable for this defamation lawsuit too. And for those reasons that we request the court to permit the designation of responsibility for third parties and that we should pull them into this lawsuit, which will make it extensively harder for Logan Paul. It'll be interesting to see how he responds to this. Because once you bring in these other parties, it deflects blame away from Coffeezilla. Especially when you're bringing up the fact again that, he got investigated. He thanked Coffeezilla for his reporting. So, I think this will... I can't wait to talk about it with Amy and Platinum, because I really think this is an interesting strategy. I don't know if it'll work, but if it does, I'm gonna it's gonna be funny. It's gonna be a good joke. It's gonna be a good joke. But anyway, that'll wrap things up for tonight. Thank you all for hanging out. It was fun. It was a lot of fun as usual. We'll see you guys Saturday for the regular Truth Be Told show.